Hi, my name is Zach McGee. I'm the chairman of New Media Legal Publishing, the sponsor of this CLE program. The presenter of this program is Andrew Struve. Andy was a brilliant, experienced, and highly successful litigator here in Southern California. On a personal level, he was also a warm, caring, and infectiously funny human being. Sadly, Andy passed away in July 2023 after a brief illness. The program you are about to watch was recorded a few years ago, but I've confirmed that the content still reflects the current state of the law on this topic. Reposting the program allows lawyers like you to continue to benefit from Andy's wisdom, and it allows those of us who knew Andy well to keep him around us for at least a little bit longer. I hope you enjoy it.
Hi there, I'm Andrew Struve. I'm a trial lawyer here in Southern California for longer than I care to remember or focus upon, and I'm here today for the fun, somewhat tongue-in-cheek subject, how to piss off a judge. Now, as enticing as it sounds, like I said, the title is tongue-in-cheek. This is actually ways to avoid pissing off a judge. However, hang a footnote on that. If anybody out there really wants to piss off a judge, email me privately and I'll share some stories. Also, I do know we get a lot of feedback on these presentations, which is terrific. It's always nice to know that people are interested, and I do welcome the feedback. I've gotten feedback from a number of judges over the time that I've been doing this, and feedback from a number of staff attorneys. And I'm particularly proud that they're listening in and watching these things. And unlike you judges and judicial staff attorneys, I actually am allowed to accept gifts, and a number of you will probably want to send me a fruit basket or something nice for some of these suggestions, I think. So just remember that at the end, and I'll try to make myself a note to mention that fruit basket again. All right, so this is not a top 10 list, it's a top 29 list, and we'll use our time accordingly. We're going to cover a lot of stuff, but you know, if even one of these things saves you considerable embarrassment or heartache, that'd be great. And some of them are actually things that'll really help, I think. A lot of these lessons are learned from, my time in practice. And some of these are no-nos that I violated myself. One thing about trying cases is you lose a certain sense of self-importance, and you're willing to laugh at yourself, at least hopefully. So I'll tell you the stories where those have come up for me, and hopefully you'll get a kick out of them. Schadenfreude and all that, as the Germans say. So, and this checklist, of course, will accompany the program as written materials, and you can keep it and hang on to it. Maybe what you want to do is give it to younger lawyers, those of you who aren't younger lawyers. And feel free to do so. I think that would constitute fair use. You paid for the program. All right, although I'm not a copyright attorney, see your Westlaw or whomever representative for guidance on that. So the first suggestion I have for how to piss off a judge: ignore the local rules and standing orders. That gets them every time. A lot of federal judges, especially magistrate judges as well as Article III judges, have their own preferences. They have their own local rules, and they do expect them to be followed. And the gatekeeper personnel in the court will enforce them rigorously. It's also very embarrassing when you violate them unintentionally, and hopefully nobody would violate them intentionally. But when you violate them unintentionally, it signals a lack of awareness of how the court practices. So where do you find these things? Well, you find them on the court's website. Also not a bad idea, if it's your first appearance or your first filing or whatever, to try to contact the court clerk and just ask if there's anything you might have missed. And keep in mind, a local rule can be, Judge X's standing order on motion practice. Maybe you'll receive that when you file the case, maybe you won't. Or it could be a general order of general applicability to the particular district or division or even courthouse that you're in. So look at those carefully, okay? And especially for the folks my age, it's really embarrassing when you violate one of these things and your stuff gets kicked. For the younger people, because then you gotta tell the client generally, and unless you can get it quickly refiled. And then for the younger people, it's really embarrassing because you got to tell me, neither one of which is a pleasant experience. Example of a local rule that'll get your pleadings kicked: there was a judge in the Southern District of New York, that's federal court obviously, who insisted that anything filed, paper copies, still required paper copies in his courtroom despite electronic filing, had to have a piece of black tape over the back end of everything that had a staple. Every staple had to have black tape. So why tape? Because he once cut his index finger on a staple. Why black? So it'd be easy for his intake people to know if there was tape there. The fella had thought of everything. All right, second way to piss off a judge: file massive stacks of pleadings and evidence. That's a horrible thing to do, especially if you're not going to use a lot of it. You can try to get an agreement in advance to use an abridged appendix or an abridged exhibit list, or, abridge the deposition yourself, right? Unless some rule requires it. You take a 300-page deposition, don't file all 300 pages, please, 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 the Lorax begs you. Instead, you'll want the cover sheets, you'll want the index to the exhibits. At the back, you'll want the jurat, right? The reporter, the witness's signature, if there is one, the reporter's certificate. But then you really only need the pages that include the testimony at issue. One warning: give a couple pages on each side if necessary to give context. Another thing that I like to do, I've never been criticized for it, and I've actually had judges say they appreciate it. Take a Sharpie and a ruler, yes, a ruler, you don't want to look like a slob, and underline the testimony you're quoting in your papers. Make life a little easier for the judge, right? Because look, I'll make it real simple, right? You're filing this stuff because you want it to be read. It will be likelier to be read if it is easy to read. This is one way to make it easier to read. Dovetails nicely with next rule: don't clearly label the exhibits and number them consecutively. Please do that. There are many local rules that don't require numbering of the actual exhibits to something consecutively. There are a lot of rules that do require it. California requires it in a number of instances, but even if it's not required, why not take all the exhibits to the declaration of bloke that could be, God forbid, hundreds of pages, and put your own Bates label in the corner of them, just like in an appellate record. That way you can cite to the Bates label. Makes the judge happy. Oh, here's another one. If you have a whole bunch of motions, like a motion for summary judgment and an opposition to a motion for class certification, set them all on the same day. Why not? It's a great way to guarantee they won't get read. And if you can find a way to do that for hearing on the Monday after a holiday weekend or the Tuesday after a holiday weekend, that'll go over great, right? I mean, it won't get read. If you're the moving party, I assume you want it to get read, and so I offer that experience for you. There are still some courts that don't require you to pre-clear dates and get reservations for motions. So don't take that as a license to simply have at it. I have a number of friends who are judges. I always try, when possible, to take a summer associate or a young lawyer. I'll say to the judge, if I know her after the hearing, I'll say, Your Honor, I want to welcome Ms. Bloke to the bar of this court. This is actually her first court appearance anywhere. And judges really like that. I mean, lawyers, I think, are natural teachers, and I will invite the judge, if she is willing, to give a few pointers on practice in her court. Well, there are a number of judges who accept that very happily and have taken a young lawyer or lawyers back into chambers. And one of them once pointed to his radiator, and kind of a box thing from the 60s, and had stacks of papers on it. He said, those are my motion papers for the week. That's Tuesday, that's Wednesday, that's Thursday, that's Friday. He goes, I'm showing you this because when you file stuff, please keep in mind, I got to take that stuff home with me, and I ride a bike to work. Make it easier, okay? And so dovetailing with this theme of please try not to put all the motions together. Some motions can be very short. I saw a motion to compel a witness to testify that was a half a page. It was a thing of beauty. I mean, it clearly stated the rule. It was obvious that the fellow was required to testify, and it got granted, and the declaration for sanctions was a thing of beauty. This was a lawyer from a very fine firm, national firm. And the declaration was, I spent 0.5 hours preparing this motion. I expect to spend 0.3 hours preparing any reply if needed, and I expect to spend 0.2 hours on the hearing of this motion. And my normal rate is $11.75 an hour, so there you go. It was a very effective motion and very well done. My next way to piss off a judge is don't make motion binders for the hearing. And don't make trial binders of exhibits for the court. You know, just bring whatever you feel like bringing and you can hand them to the bench. That's a joke. Do it. You know, if you have a motion, right, you get the motion on file. If it's a big motion, if it's a summary judgment motion, motion for class certification, something like that, you can get the thing on file and then talk to the clerk and find out ask if the judge would appreciate not just a bench copy, but a motion binder. And then you could put a nice binder together with all the papers in it. You can do this after the reply briefing's in. You put all the papers together with a beautiful little index. You'll look so much better than everybody else. And the judge will appreciate it. And so I would really encourage you to do that. Trial is the same thing. At trial, you know, one key part of trial preparation, remember, it's not all about you. We'll get to that later. It's not all about you. You want to make it as easy as you can for the court. Talk to the clerk and the staff attorney. Often before a big trial, you shall be introduced to the staff attorney. If not, seek out the staff attorney and ask what would be easiest for her. And do it her way. You might have a preferred way of doing things. That's nice for you. But again, part of being an advocate, part of getting the court to rule in your favor, is to make the court want to rule in your favor. It's nice if the law is in your favor. Some people tell the court they have to rule for them. Well, you'd be surprised how many judges can escape having to do something they don't want to do. The highest form of persuasion is to make the court want to rule for you. So please, in your papers, make it easy. And that's another way to do it, just like the underlining and the consecutive numbering that I mentioned earlier. These seem like silly things, but I can tell you that the hallmark of a real pro, and the judge will know it. Here's another way to piss off a judge. Mention to your judge how favorably some of his other colleagues handle certain issues. They always enjoy that, being told that their own preferred method of doing something, really they ought to take a page out of Judge Baker's playbook down the hall and do it the way Judge Baker does it, because it works really well. I got a news flash for you as a guy who's worked in courts. Being on the same court, whether it's an appellate court or a trial court, you have your colleagues on the court, but it's a lot like a law firm partnership, except you didn't get to pick the other folks that you sit with. So a lot of the time it's like a law firm partnership where the partners don't necessarily like each other. For all you know, your judge may hate the fellow down the hall. Don't make recommendations. Just say, one way I've seen this done, or perhaps I might suggest. And the phrase that I throw in on procedure is, Your Honor, I'm highly cognizant of the fact that this is your courtroom and we're going to do it your way. Having said that, I do have an idea. I've gotten a lot of judges say, you're absolutely right, after I tell them we're going to do it her way. But that's obvious. Of course you're going to do it her way. But just tip a little hat to the fact that you're willing to do whatever procedure they envision. But propose your own. It can't hurt. Do it in a very polite way, and you might even get it. Another nice way to piss off a judge, don't forget that your case is the most important case out there. It's the most important to you, and hence it should be the most important to the court as well. Some lawyers seem to exude that by their very presence. They'll do things like they'll ask for calendar preference when they don't really have a basis for calendar preference. They just want to get out of there early. Well, newsflash, everybody wants to get out of there early. And you should assume if there's a lengthy hearing calendar, or indeed any hearing calendar with some matters on it, that the judge is likeliest to take the non-appearance matters first, the non-contested matters after that, the simplest matters after that, and save the more complicated ones for last. And so just recognize that. Don't try to jump the line ahead of everybody else. The court will perceive you as trying to dictate to the court what it should do, how it should handle its docket. In federal court, and also in some state courts that have combined, you will find yourself in state court sometimes, and I'm not going to pick on any particular jurisdictions, where they'll have one judge that has a combined civil, criminal, family, and probate docket on the same morning, right? Well, you'll be stunned and amazed to find them take the criminal cases first. Well, that often happens, right? That often happens because you've got all kinds of sheriff's deputies or U.S. deputy marshals standing around, and you got prisoners that have to be moved and fed. And believe it or not, there's a whole body of regulations about how you have to move them and feed them. Expect to wait. The same thing goes for a sentencing hearing. They can take some time in federal court. Expect to wait. Judges are humans, okay? You got a defendant there, just got out of the shackles for the sentencing hearing. Lengthy sentencing memo to consider. There's victim impact statements. You got the victim sitting there. You got the family members sitting there. You got the mom of the defendant sitting there. You really think any of them should have to wait while you talk about class certification? No, don't be surprised when it happens. And for the love of God, don't complain about it. Another way to piss off a judge: misrepresent the procedural history of the case. I have known lawyers who have done this with consistency. I have pointed out to those lawyers that they were misrepresenting the case, and they continued to do it for months or even years afterward. It's very unfair. It's unfair to the other side. It's really unfair to the court. You know, a lot of courts, you'll have a judge that's carrying a caseload of 500 cases or so. They can't remember the procedural history. And the electronic docket they look at is really, in most cases, in most courts, no more illustrative than the one that you can get online. Help them out and tell the truth about the procedural history. This is especially the case if you have multiple judges on a matter, like a magistrate judge in federal court and then an Article III judge, or, God help you, a discovery referee and then a magistrate judge and then an Article III judge. Don't create conflict between these judges, please, and don't lie about what happened. The system doesn't work when people do that. My next way to piss off a judge that dovetails nicely with that: lie about the facts and be sure you get caught. A case comes to mind that I had in the LA Superior Court. And we were not the home team, and we were not necessarily the most sympathetic team, but we did catch counsel for the other side lying about the facts. He made a representation of the court that was entirely contrary to one of his sworn declarations from 2 years earlier in the same case, and we were lucky enough to have that at our fingertips, and we pointed that out to the judge, and the judge gave an extremely hard look at the counsel for the other side, just basically stared him down. And the poor fellow never won anything else in that case in that court. That just sealed it. The judge had obviously come to the conclusion that the misrepresentation was deliberate. By the way, footnote on that: if there is a misrepresentation by the other side and you're not certain it's deliberate, please don't tell the court it was deliberate. You can make a suggestion like, almost surely unknowingly. Well, that leaves enough room there for the judge to draw her own conclusions about whether the misrepresentation was intentional or not. A judge is more likely, by the way, to come to that conclusion if you don't tell the judge that. Sometimes it's better to leave the conclusions for the judge. Ad hominem attacks on opposing counsel. Jokingly, I would say judges love those. No, judges hate those. Basically, when you do that, you're just telling the judge what she should decide. If opposing counsel is a total nitwit, The judge will figure that out, and that'll be evident from the papers. You don't have to lace yours with all kinds of invective about how your opponent's a nitwit. And the neat thing about nitwits is they're self-proving. All you have to do is let them roll themselves out of the hangar, and the judge will reach her conclusions very quickly about it. There is a great footnote buried in Calap Fourth somewhere. A friend of mine wrote it for a judge who was also a friend, now deceased. Great footnote that talks about the impropriety of ad hominem attacks. I'd give you the citation if I had it in mind, but you will find it because here's the footnote. It discusses the ineffectiveness and inappropriateness of ad hominem attacks, and then it gives an example of one from the old Saturday Night Live, first cast with Jane Curtin, where Rosanna Dana, played by the deceased and much missed Gilda Radner, would be on the news segment and would refer, when she was rebuffed by Jane Curtin, she would say, "Jane, you ignorant blank." So if you want the footnote on crumminess of impropriety of ad hominem attacks, just run "Jane, you ignorant" in the California reports, and it'll probably be the only case that comes up. There, I don't even have to give you a citation. Same way to piss off a judge, similar thing dovetails. Snarky comments about the merits, about counterparties, and about witnesses. Please, why? Okay? Don't demean the counterparties, don't demean the witnesses. That's another thing that's self-proving. If a witness is a bald-faced liar, it'll be obvious to the court. You can politely reference things like the conceitedly or the inarguably dubious nature of the persuasive effect of the testimony of bloke, or something like that. But please try to do it in a way. Don't throw around words like liar and those kind of things. I've seen it. Sometimes it'll be ignored, but when it isn't, you're going to hate your day in court. And when you do stuff like that, by the way, that's one way to get your case called first. All of a sudden, you're called first. Wow, this is great. I'm going to be in the cafeteria by 8:45. Yeah, you might be, but first you're going to be humiliated in front of a whole courtroom full of lawyers. Don't do it, okay? Insult other judges. That's always a great thing. There are a bunch of appellate opinions I've seen where the losing party, always the losing party for reasons that you can well imagine, really goes after the trial judge, basically makes the trial judge, accuses the trial judge of being inattentive, disingenuous. That's a great word to piss off a court. Try not to use that. Find something else, right? You can demean the heck out of the trial judge below. Well, I got news for you. A lot of appellate judges, they came up, they got elevated from the trial court. This may be their best friend for life. This may be their former friend from the prosecution defender's office. Don't do it, right? I mean, if there was error, there was error. You don't have to say the judge was a moron. And by the way, here's a little thing for you about when your trial judge is a moron, and they do exist. This fact of incompetence by the trial judge was already well known to the Court of Appeal in the relevant district. You are not pointing out anything new. I worked in a Court of Appeal, and there were appellate justices in that court on several occasions who would pick up some new AOB, appellate opening brief that came in, and they'd say, "Oh, Judge Bloke, yeah, Judge Bloke's a moron. You might want to give this a particularly hard look." The appellate court knows it. This is their world. You're not teaching them anything new. There's no reason to say it. If Judge Moron has a reputation that's bad, it's already known to them. So, be sure to show bias and cultural insensitivity. That's a beautiful thing. I mean, obviously, don't do that. By the way, doing that is conceivably grounds to get disciplined by the bar. If you exhibit bias, and keep in mind the 2021-2025 wide-ranging standard of bias, right? If you exhibit it, you may well get referred to the bar for discipline. And people refer things to the bar all the time, complaining about their opposing counsel. I will tell you this, if the referral comes from a judge, it is much likelier to get attention. Hey, maybe all you'll get is a letter of censure. Yeah, a letter of censure for showing cultural bias that's a public document that's appended to your bar record and that's accessible by anybody with access to the internet who looks up your bar history. You really don't want that, okay? And insensitivity, God help me, some of the times I've gotten in the most trouble, I will admit, is when somebody else did the moving papers and for whatever reason I parachute in for the hearing. Well, one of my colleagues, a fellow whom I like very much personally, made the mistake of calling our opponent's arguments schizophrenic. You know, in the technical sense, they were somewhat schizophrenic, but unfortunately, in the medical sense, so was the judge's daughter, which he explained to me. What I did not do was say somebody else wrote it. It's the other guy's fault. Because, hey, I'm there. You know, I am the other guy, right? I mean, there's no point, and it makes you look like a weasel. I just took it and I said, utmost apologies, Your Honor. I'll make sure I never do that again. Just own it. There's no point. And for God's sake, another way to piss off a judge, blame it on your secretary, blame it on a paralegal. Come on, guys. You're the captain of the ship, okay? Just own it. If your paralegal screws up, you screwed up, you didn't catch it, the buck stops here. It's like if you're the chief surgeon in a surgery, please don't say it was somebody else's job, because I got to be honest with you, it might be somebody else's job to count the sponges, but it's your job to make sure the sponges got counted. All right, so picking up with other ways to piss off a judge here, here's another great one. Use the phrase "with all due respect." Now, I will tell you, some people use that meaning to be respectful. It actually means the exact opposite. Judges will point that out to counsel sometimes. I've heard it on many occasions. I've heard judges say, please don't say that. That means you have no respect. It can be interpreted also in a negative way as meaning you have respect for the office of the judge, for the robe, but not for the man. That's not a way to win friends and influence people, okay? Park the phrase "with all due respect." If you intend to show respect, you can say, Your Honor, and I mean this in the most respectful and polite fashion. Give that a try, okay? Kind of helps if you're sincere about it, or at least can seem like you're sincere about it. But that eliminates this "with all due respect." Just lose it. Parenthetical. Another great way to piss off a judge, at least one who's a student of English, is to litter your stuff with "including but not limited to." What a useless piece of garbage phrase. I got news for some of you out there, and lexicographers will get a laugh out of this because they know what I'm going to say. The word "including" means but not limited to, okay? All right, there's nothing in the word "including" that means exclusively. There's another word for that, to wit, exclusively. All righty. Now, in the same vein, use really big, arcane, complex words to show the court how smart you are. This is great stuff. I throw some Latin around in there. Now, in fairness, I will sometimes say a fortiori. I am guilty occasionally of saying that an argument is tautological. Nobody's ever called me on that, and perhaps some people have had to look up what a tautology is, and I highly commend it to them. But in general, please skip the big words. Here's why. Arguably, they may make you seem like a scholar. But what you're going for in any written submission to the court is not scholarship, but clarity, right? You want to make your papers easy to read. And I'll tell you this, quite often I will do a major motion, I'll do an introduction, then I'll do a summary argument. And I'll try to say the whole thing in the summary argument. And then the memorandum that follows, the memorandum of law that follows, can contain all the case citations and everything else. But my fond hope is with the intro and the summary argument, I can get the judge to stop reading, okay? Especially if the principles of law are clear. She may glance through the rest of it, but make it simple. Here's another problem with when you use really big words. Show how smart you are, right? The judge may not know the words, even more likely the law clerk or staff attorney reading the brief may not know the words. So what do? They don't view this as a fun opportunity to haul out the Merriam-Webster, God, I'm dating myself, sorry, to go on the internet and look up what the word means. They don't take great joy in learning a new word from you. Actually, they think you're insert invective here, ad hominem attack, and even if they don't specifically think that you are that word, you will piss them off, perhaps without them even recognizing it, because it makes them feel stupid. Okay? Making somebody feel stupid is not a great way to be persuasive, not a great way to win an argument. It also, at the very least, even if the word is understood, it makes the sentence harder to read. Okay? Now, so if you're the judge or the staff attorney and you have a pile of motions this big, you want easy reading. Why use a $5 word when a 50-cent word will do? There's no point. Okay? Or another one that I can't stand when I'm reading it, when people flip around their name for something. If something is the same, call it the same thing the whole time. Don't have two names for the same document. Don't have two words for the same party, right? Don't flip between the term plaintiff and bloke and plaintiff and cross defendant. There's no point. Name them, okay? Some people prefer plaintiff and defendant. I leave that to you. It sort of depends if you have a sympathetic client, at least subtly so, right? If I have a hospital, I'll name them hospital, whether they're the plaintiff or the defendant, right? Hospitals are good. Conversely, if you have payday lender, I don't think I'd name them payday lender. I think I'd call them defendant. So I leave that to you. Apologies to the payday lenders. We have family friends in that business. But my apologies are limited. Oh, here's another one. Throw in a lot of quotes from Shakespeare to show how smart you are. You know what? Enough, okay? Anybody who's read Shakespeare knows the quotes. You're not as funny as you sound. Not as erudite as you think you are. There may be times for some quotes. I will admit that occasionally, if somebody has violated the rules against motions for seeking reconsideration without any new issues of fact or law, or if they keep making the same arguments in opposition to repeated motions to dismiss, I may say, you can use this, it comes free with the lecture, I may say, as Yogi Berra said, it's like deja vu all over again. You might get a laugh. Or if an argument is, totally vacant, I may say, without attribution, the reference was made to the city of Oakland, by the way, I may say there's no there. Here's another one that follows the same way. And I'll lead into it this way. Please, dear God, don't blame it on the judge's poor clerk, okay? This clerk is intensely important to her ability to function as a judge. Do not pick on the court staff ever, okay? Ever. They might be the worst in the world. Don't say a word. I will tell you this. One way to tell if you have a good judge, and I know I got some judges listening, I know I have some court personnel listening. If the court personnel in the courtroom, when you come into that courtroom cold for the first time ever and the hearing hasn't started yet, if they're happy and in a good mood and, nicely presented and that kind of thing, odds are more likely than not you got a good judge, right? A good judge has happy staff, just like a good lawyer, good manager of anything, good restaurant manager has happy staff. If, on the other hand, the court personnel in the room appear to you kind of like the little dog in The Grinch Who Stole Christmas, the dog who pulled the sled, caution, be very careful. You may have a bit of a tyrant on your hands. But again, way to piss off a judge I have, be mean to court clerks, reporters, and bailiffs. Be sure to lord it over them because you're a lawyer and they're not. Guys, you don't get promoted to equity bailiff or equity clerk, okay? Your income doesn't rise exponentially over the years. Be nice to them. It's not easy to do a job that repetitious, okay? Here's another little thing about how you treat the clerks and the bailiffs and the staff attorneys and anybody else in the courtroom. You're in the courtroom, you're having a conversation with one of those people, and the judge isn't on the bench, so no problem. You know, you're a little freer and looser in what you're saying, right? Bad news, guys. A lot of courtrooms are wired for sound, and there's a speaker box in the judge's chambers, usually on her desk, that she can turn on and off. I have had on several occasions in different courts, judges demonstrate these speaker boxes to me, especially in recent decades with the number of shootings, unfortunately, that we've had in courts. These were installed as a safety measure. I will admit that I have had at least several judges tell me while we shot the breeze in chambers that they use these to listen in on what's being said about them or the case before they take the bench. You should assume, just like you would if you were in a hostile embassy, that everything you say in that room is being heard by the judge, and by the way, maybe recorded, okay? There you go. That alone should get me the fruit basket, if not a check for $100. My address also widely available on the internet. Okay, other things that you can do to piss off a judge. Miscite authorities. That is really annoying. If you expect the judge to care about your motion, your case, your presentation, please cite check the authorities. Please don't cite things that are not published. Please don't cite things that are under review. This sounds obvious, but I see it so many times. I recall an argument in the United States District Court of Appeal for the Second Circuit where a particular proposition was argued by one of the parties in a brief and then was argued at oral argument. And that drew a question from the three-judge panel. Counsel, can you point out to me where in the case it says that? Because I have looked and I did not see it. And this counsel, God bless his little heart, said, well, it's not easily found in the case, but it's found in the head note. Oh, wonderful. So it's not in the case itself, but somebody blew the head note, and so you're citing a head note. True story, I was there, right? Please, don't do it. Oh, here's another fun one. When possible, threaten to take the judge up on an emergency writ. They love that. There is no chance in the world that the judge will alter her conduct because you have just threatened her that you'll run off to the Court of Appeal. And if, by the way, you have a magic bullet in your pocket, for example, if you're facing a temporary restraining order or a preliminary injunction against you and the enforcement order would be stayed by the filing of a notice of appeal, and by the way, if it's a mandatory injunction, a lot of jurisdictions it would, you don't have to tell the judge that. All you have to do is have the notice of appeal neatly folded in the requisite number of copies in your jacket pocket, and then walk across the street and file the appeal, okay? So there's no reason. If you're going to go up on appeal, go up on appeal. No reason to threaten the judge with it, okay? They won't be impressed. Oh, here's another great one. At trial, try to impose your own timing needs upon the court. For example, don't have enough witnesses ready during a trial day. I can tell you from long experience, you do not know how quickly you may or may not get a witness on or off the stand. You may find yourself with a new judge in a situation where a witness that you have every plan and intention on taking 2 hours with, the judge will make it quite clear to you that we're going to have a no BS direct examination, and will make it quite clear to you to move on. May even take over some of the questioning himself, God bless him. And that witness will be off the stand in 20 minutes. And depending on strategy, your opponent may not have any cross. And if she doesn't have any cross, you won't have any redirect, and that witness is out of there. Next witness, please. Counselor, are you ready to call your next witness? You don't have any witnesses ready. Why don't you have any witnesses ready? Have you read my standing orders, etc.? You have your witnesses ready. Here's a fun story. I had a third-party witness once in a very long, trifurcated trial, and we were in about week 8 of the first of 3 parts of this trial. So we had a private equity guy from New York that had been an intimate part of a transaction that was the subject matter of the case, and we needed him to come in and testify, but we didn't control him, and he wasn't even really necessarily subject to the jurisdiction of the court. But we got an agreement from him that he would come in that week on Thursday. It doesn't matter what day of the week it was, Wednesday or Thursday. He said he could fly into Orange County John Wayne Airport on his jet, of course, by about 11, but he had to leave by 2:30 to get up to the Bay Area for a dinner. And I just listened to all this, and I giggled to myself, and I thought, this is too good to handle just by myself. I said, okay, well, look, that's going to pose a little difficulty, but let me see what I can do. And then I joyfully walked down the hall to my partner's office who was trying the case with me, and I said, Tom, well, good news. I got Bloke, and he's going to come, but he can only come on Thursday, and he lands at 11, and we have to get him back to the airport by 2:30. Knowing that it would blow the top of my partner's head off, so I had to do it. And he said, "Oh, hey, no problem at all. You know what? I'll handle this. I'll just tell the judge that we have a witness who's special, right? I mean, he's a rich guy, and rich guys have to be treated special. We got a rich guy witness, so we got to do it this way." No, we handled it differently. We had a couple of his former partners who actually had their reputations and money on the line tell him to get his blank, 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 and maybe a few more blanks to Orange County and stick around until we were done with him, which is exactly what he did. Dovetailing nicely with that, how to piss off a judge, disrespect the value of the juror's time. Hey, you know what? They're just postmen. They're just, DMV workers. They're just court clerks. The hell with them. They can sit around. This game's all about us. The heck with the juror's time. I will tell you from experience that judges are very protective of jurors. Here's a heads up. You can't try a case without them, right? And you want them to have at least a passable jury experience. They are not there of their own volition, but they're also not irresponsible enough to jump service, as very many people do, by the way. If we actually issued bench warrants for everybody who jumped jury service, we wouldn't have enough buses to take them into court. And then where would we get the jurors, right? So look, you have to be ultra respectful of the juror's time. That kind of dovetails with the witnesses and that kind of thing. Convey to the court in the beginning of the trial the fact that you appreciate the court's interest in everybody having respect for the juror's time. If you say it ahead of time, the judge doesn't have to tell it to you. And I'll bet you one of the fruit baskets I now have on the way that the court will say, that's absolutely right. We are going to be entirely respectful of the juror's time in this matter. Same thing goes for if a juror has a funeral. Please don't suggest to the judge that really it would be in everybody's best interest if the juror skipped the funeral. You almost certainly, hopefully, won't get away with it. If the jury catches wind of it, they'll hate you, right? Show a little bit of humanity, okay? That also means don't deliberately stall out a jury. Being respectful of jurors' time, let me give you one more example of it, okay? Trial estimates. If you give, agreed upon in advance, hopefully with your opposing counsel, a 2-week trial estimate, well, that means a 2-week trial estimate, okay? That means how long it'll take. And if you give it 2 weeks, and I don't care, pick a number, 1 week, 10 weeks, whatever your trial estimate is, that's what they're going to qualify the jury for, okay? They're time qualified. There are certain people who cannot stay longer than 2 weeks. Maybe they don't get paid for more than 2 weeks, or maybe they get paid and they get child care paid, but it ends at 2 weeks. Judges are very sensitive, trial judges at least, are very sensitive to how time qualified your jury is. Why? Because if you run over time, or as a presiding judge once described it to one of my opponents, if you turn it into a Ben-Hur production, you'll start losing jurors. And there's only so many alternates. In a lot of cases, there may only be 2, 3. If you start losing jurors, you know what happens when you run out of alternates? You lose one more juror, you got a mistrial. And you can't control how you're going to lose that juror. Okay? Their poor kid may come down with some horrible dengue fever overnight. You've lost that juror. The kid's in the children's hospital. You got a mistrial. And when you get a mistrial, my friend, you have one pissed judge. And by the way, you get the same judge for the retrial. Enjoy yourselves. Another thing, overpromise your intentions regarding, here's a way to piss off the court, overpromise your intentions regarding submission deadlines, regarding exhibit deadlines, regarding compliance with timelines, regarding trial readiness. Please, if you make a commitment to any of those things, that's a commitment to the court, right? And it helps the administration of the court. And if you think your life is busy and hard, this poor lady up there with the 500 cases or 400 cases or whatever, and then her staff, just be realistic, okay? If something can't be done, and I don't want to hear can't be done because you have a vacation prepaid in Cozumel. Look, quite frankly, if you're a trial lawyer, you ought to be making enough money to be able to rebook that trip, okay? I know I'm going to hate myself because somebody will quote that back to me sometime, but that's kind of the way I live it. I happily watched my entire family go off for a wonderful trip to Hawaii without me. I got some really nice pictures. Happens, okay? Here's another thing, really a great way to piss off a court. Mess up all the jury instructions, okay? Just, come up with a whole bunch of BS and then don't even work hard with the other side on agreeing upon jury instructions. You can file your set, and there are probably this many binders, and she can file her set, and then the judge will figure it all out, right? Wrong. Please, for the love of God, try to agree upon the jury instructions ahead of time, all right? Here's another thing. It's less of a problem if you agree upon a specific instruction, okay? But if you want an instruction given that the other side doesn't or whatever, and I'm saying this for your own good, don't just make it up. Please have it actually mirror the case law, all right? Use the sample jury instructions, etc. Because if you get a jury instruction in that's kind of halfway made up or is what the law is you think it ought to be stated or whatever, and that instruction gets given over the other side's objection, you won the case, that's great. You also got reversible error, okay? You don't want to win via reversible error, all right? And the trial judge gets reversed because of some of your jury instructions. Oops, nobody likes that. Same thing as long as we're on the jury. How to piss off a judge, my notes say 50-page jury questionnaires are fun. They might be fun for you. They're hell on the jury, okay? Now, I could give an afternoon lecture on strategies of jury questionnaires and what should be in there and what shouldn't be in there. The judge is not going to give 50 pages. Try to come up with something rational. You can err on the side of length, and obviously you have a responsibility to your clients to represent them to the best of your abilities. So don't leave anything out at my behest. But try to be rational and work with your trial colleagues, right, on their views of acceptable jury questionnaires. Share it with them beforehand. If you're lucky enough to be able to afford a jury consultant, preview the jury questionnaire with the jury consultant. That's one of their functions, right? So try to come into the court with documents that are acceptable, okay? How to piss off a judge, another way, have exhibits that you are unable to lay a foundation for. That's wonderful. Really, on your working copy of any important trial exhibit, you ought to have a roadmap for the foundation to get the thing admitted into evidence, to reference it to. You can get awfully tired. I can tell you this from experience. You can get awfully tired during a day of trial. You may kind of forget the pathway to admissibility. And it's good if you happen to have it. If you have it scrawled on your own copy of the document, all the better. And that's a big thing. By the way, the procedure for admissibility of documents can vary dramatically between different courtrooms. There are some judges who take a very formalistic approach to admissibility. And if you haven't encountered it before, it will be hell for you, I promise. And having to fumble your way through trying to get an exhibit into evidence, if you don't know the way the judge does it, is another guaranteed way to piss off a judge. What you might want to do is subtly explore at the final pretrial conference, which is usually a week before trial is scheduled, explore how the judge wants to handle issues regarding admissibility of documents and admission into evidence, okay? Just make sure that we all are in agreement on that, all right? Because you may otherwise be unpleasantly surprised. Another great way to piss off a judge, contaminate the jury pool. That's great. I mean, the worst, frankly, is doing something that results in an automatic mistrial. I will leave it to others to talk about strategic mistrials. I'm not going to even climb into that swamp. But sometimes during voir dire, or as people who didn't take high school French call it voir dire, you can ask a question of a juror that will have the effect of so prejudicing the jury that you will contaminate the entire pool. Judges hate that because, again, judges care about jurors, and by doing that, you just wasted the entire day of not just the people who are in the box, but the whole bunch of people who are sitting in the pews behind them, because they now all have to go and you got to replace them. Great way to annoy the court. Don't contaminate the jury pool. Other ways to really piss off a judge. Here's one. This goes back to the written submissions point. I've seen people do it. Good God. When you cite a case somewhere in your papers, please, 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 for the love of God, read the names of the other lawyers. A lot of people don't do that. Every now and then, and it's been delicious, I've had a case where the other side has taken same person has taken an entirely contrary position or contrary view on something. It's always a pleasure to cite that to them in my proceeding. Most judges were practicing lawyers before they were judges. Practicing lawyers who become judges are often litigators. You'll be shocked and amazed to know that litigators actually have cases, right? Published opinions, trial court opinions, administrative opinions, court of appeals opinions, right? And sometimes they come out on the losing side. As we talked about earlier, appellate judges or justices quite often were trial judges, okay? If you can, try not to cite to the judge a case in which he had represented the losing party or in which she had been reversed on appeal. That really cuts kind of close to home, and you may not do it on purpose. They may not tell you you've done it. Please try not to do it. And show some knowledge. You know, I can phrase it in the piss-off way if you like. One way to piss off a court is to show a total lack of awareness as to its history. And that's an important thing, quite frankly. There was a judge in the Second Circuit of New York, Manton, I believe his name was, who was convicted for bribery, for throwing cases back in the early part of the 20th century. And somebody who's not an experienced practitioner in the Second Circuit might cite a Manton opinion. They don't do it. They don't ever do it. They can't depublish them really, but they're taboo. They say I can't rely on it because I never know whether it was bought and paid for. They don't want anything to do with it. So, you know, piss off a judge by not showing any awareness of their procedures, okay? Another great way to annoy the judge is to explain to the court that another court is more important. Your Honor, I have a conflict. I really would ask for a recess today at 11 o'clock because I have another matter with a hearing, and that's in a federal court. Oh, God. You know, you tell a state court judge impliedly, or worse yet, explicitly, that a United States judge is more important. If you're really lucky, you get a very self-actualized state court judge who will laugh at it and just say something like, ah, yes, I know the ivory tower, the powers of Article 3. Congratulations, you lucked out. a lot of them will be very pissed off. And by the way, that goes for one of their colleagues. If you say, I have to do this because I have an appearance before Judge Kimberly down the hall at 11 o'clock, okay? You got to do these things delicately, all right? You got to do it delicately. Have the clerk talk to Judge Kimberly's clerk and ask the clerks how they'd like to handle it. It shows them some deference, okay? Back to my earlier comment about how to piss off a judge by not treating the court staff well. It has come to my attention in recent years that there are some courts, some divisions in particular, where the court clerks really like to be called Madam Clerk. It's a thing of beauty. It's 2 words, and it costs me absolutely nothing. If I can win some additional good feelings at something that costs me absolutely nothing, go for it, please, okay? Ditto for correct pronunciations. If you have names that are exotic, don't try to tough it out on your own. Ask somebody who speaks the language how to pronounce it, okay? Especially the judge's name. Great way to piss somebody off. You'll notice a lot of the time if your name is somewhat complicated like mine, the judge will often ask you how you pronounce it. You always get a laugh and say, I pronounce it any way Your Honor does. Yeah, you get a laugh when you can, okay? Depending on the personality of your judge. You say, I pronounce it any way Your Honor does, but given my preference, it'd be Struve. What the heck? Set the right tone. Show awareness of your surroundings. You can piss off a judge by not showing awareness of your surroundings. Judge asks a question, butts right into the middle of your argument with a question. It might be a tough question. I've seen some people say, that's a great point, Your Honor, and I'll get to it, and then soldier on with whatever you were talking about. No. Stop and address the damn question, at least briefly, and say, but that fits right in with the point about the fact that you don't even reach the question of unconscionability until you reach the question of formation, whatever the heck it is, okay? So you try to be polite about it that way. There are some people who piss off a judge by being larger than life in the courtroom. They make it very clear when they enter the room that they're an exalted figure and all else are subservient beings. You've seen such people on the news. Judges don't appreciate it because it makes it harder for them to run their courtroom. And it's also offensive to the judge because deep down, I think a lot of them have the view that, given the fact that they're burdened with running the proceeding, they also should have the benefit of being the center of attention in the room. And I think that's right. And also, you got to be, a way to piss off a judge is not to be aware of your role, okay? And there are some ways as an advocate that you can actually you can have awareness of your role that is very powerful. One of the trial lawyers I learned from, it was a great case. It was a groundwater contamination case involving all the major oil companies, and it went to jury trial on this massive alleged groundwater contamination. And so there were lawyers from very fine firms for all the usual oil companies. Just in your head start ticking off the names of all the gas stations you've seen, and you got them all, right? And we represented a comparatively small oil company, only had about 700 stations. And the lawyers for the defense were jockeying for seats of importance. You'll see this in cases involving large groups of corporate defendants. There's kind of an internal competition for who sits where and who gets to be up front. I'll give you a heads up for anybody who hasn't learned this already. The people who are up front and taking the lead are viewed by the jurors as likely the most responsible party. So my mentor in this respect, courtroom was overflowing. He took a little desk over by the window, kind of down in the back, almost in the gallery. And during the worst parts of the testimony, he just sat there and he worked. And I swear to you, he looked like a student at a desk off in the corner, and the jury, I can't even remember how it came out. If we got tagged very minimally. And the people who sat in the front row, they paid more, and I'll leave it at that. Another way to piss off a judge is make sure you try your case in the press. You know the people. go ahead and make all kinds of statements to the press before and after. Now look, there are reasons as a zealous advocate that you have to do these things sometimes, but you all know who I'm talking about. And you would see the ire on the judge's face if you were in a proceeding or watching a televised proceeding where somebody does that. So, again, it's a question of showing a little bit of humility, right? Judges appreciate that very much. And juries appreciate that too. I remember hearings where, in federal court in recent years where the proceeding that went directly in front of mine was it was hotly debated. The judge was pretty annoyed at conduct of one of the counsel, and he actually looked pretty heated by the time the thing was over. A little bit of red in the face. This is a gentleman I'd known for some decades. And so I get called next. This is great. You want a hot bench? I got a judge right now on the bench whose blood pressure is way out of the normal range, right? And so I figure it's time to kind of take a little bit of the air out of the room. And so the case is called, and up there, and I said, Andrew Struve with some trepidation for the plaintiffs, Your Honor. And that got an immediate laugh out of him. As did when I mentioned we were going to select some mediators. And he said, who were you thinking of? And I said, oh, the usual suspects. And he got a good kick out of that. So just try to take the temperature of the room and don't be tone deaf. You can piss off a judge by being tone deaf. And I guess, one of the things I would say is, and I'm not even going to bother with the don't piss off on this, closing thought for y'all. If you can, try to show gratitude to the participants in the proceeding. You're getting paid to be there, they're getting paid to be there, except the jurors who are getting nothing. They're getting a bologna sandwich and parking and maybe $30. Show gratitude for the other participants in the process. There is no justice without those participants. Jury trial, constitutionally guaranteed for certain kinds of cases. Can't do it without a jury. People stop showing up. You're not going to have a trial. People don't want to be judges. You'll still get judges, but you get lousy ones. Try to make it a livable experience. Show your professionalism for it. Exhibit gratitude when you can, and then not only how not to piss off a judge, but how actually to get gratitude back. Take your lumps. Not everything is going to go the way you want it. And don't have a snitty fit and a tantrum and stamp your feet. Pretty clear, if something's not going to work, then it's not going to work. All right? So just, stand up and take it. I hope you got something out of this. Please pass along any of it. If it helps you in any other way, I will be truly gratified to know it. Feel free to drop me a line, and I wish you a pleasant rest of your day.